Mr. Walsh.
Thank you, Madam Chair and honorable senators. It's a real privilege and an honor to appear before the committee today, and I hope my participation is useful as you pull together your report before the end of the month. I'm going to speak briefly now and hope that my full statement could be entered for your record in evidence. Just to be clear at the outset about WOLA's posture with regard to legal regulated cannabis, we consider legal regulation of cannabis to be a sensible and promising alternative to prohibition, and we have engaged extensively in recent years with governments, multilateral agencies, and civil society partners exploring how to move forward with cannabis regulation in ways that support human rights, public health, and social justice. Just last month, WOLA and our colleagues at the Brookings Institution in Washington published a report entitled Uruguay's Cannabis Law, Pioneering a New Paradigm, taking stock of the Uruguayan law's advances and challenges since it was enacted. This is the report. We would like to make that available as well. Overall, my message to the committee today is one of reassurance. I believe that, first, Canada has sound reasons for moving forward now with its cannabis law reform for the health, security, and well-being of Canadians, even though doing so will inevitably entail noncompliance with certain drug treaty obligations. The drug treaty noncompliance that Canada's shift will entail has remedies in international law. And Canada's international reputation as a good global citizen need not suffer along the way. To the contrary, my colleague Martin will discuss the options available to Canada, in particular the procedure of inter se treaty modification. Also, Canada can avoid the kinds of banking access problems now facing Uruguay and thereby contribute to the regulatory aims of transparency, accountability, and public safety. Finally, time is on Canada's side. Canada is at the vanguard of cannabis regulation, but it is not alone. In addition to Uruguay and developments within the United States, other countries are contemplating similar reforms for similar reasons. As Canada moves forward with cannabis regulation, it will find itself increasingly in good company. To substantiate on these main messages of reassurance, I'll elaborate here briefly on just 3 points. First, Uruguay enjoys continued good standing in the international community. More than 4 years after having enacted its cannabis regulation law, Uruguay is not an international outcast, has not suffered sanctions or otherwise been punished for moving ahead with its reform. Uruguay maintains that its policy is fully in line with the original objectives of the UN drug control treaties emphasized, but have subsequently failed to achieve, protecting the health and welfare of humankind. Uruguay has sidestepped the noncompliance question, arguing that its new law adheres to the country's foundational obligations under international law. In the event of a conflict between human rights obligations and drug control requirements, Uruguay argues that it is bound to give priority to its human rights obligations. Historically, countries such as the United States have used their considerable power to encourage full implementation of the drug treaties and to discourage innovations that break from the orthodoxy of prohibition and criminalization. However, with Uruguay's cannabis law entering its 5th year, there has not been a concerted U.S. effort to punish Uruguay, either bilaterally or in the wider international arena. In this respect, Uruguay has enjoyed felicitous timing, with its law's passage having come in the midst of a major shift toward cannabis regulation within the United States itself. Uruguay's human rights rationale for adopting a regulatory approach to cannabis provides a powerful case for moving ahead, even though regulation entails breaching certain drug treaty obligations. However, the human rights arguments for regulation do not automatically resolve the legal conflict within the current treaties or somehow erase the issue of noncompliance. Uruguay was understandably reluctant to take the step of openly acknowledging treaty noncompliance entirely on its own, potentially isolated and without obvious allies. Rather, Uruguay judged that it would be better to reckon with that challenge in the international arena once other countries found themselves confronting the same problem, as Canada is today, and as other countries will likely be in the not-too-distant future. So while human rights-based arguments and appeals to the fundamental health and welfare goals of the drug treaties do not resolve the issue of noncompliance, Such arguments do provide a strong justification for a country to enter into a temporary period of drug treaty noncompliance with the intention of formally altering its relationship to the international obligations that it has decided it can no longer meet. As Martin will describe, such a period of transitionary, respectful noncompliance could set the stage for two or more countries to avail themselves of the inter se option for treaty modification. Briefly on my two other points, Canada can avoid the banking problems that have hampered Uruguay. Where Uruguay was highly vulnerable given its relatively small economy and significant reliance on U.S.-based banks, Canada has attributes that should help avoid those obstacles. First, Canada already has experience with the medical cannabis sector, something Uruguay is only now developing. Second, Canada's overall population, economy, and cannabis markets are orders of magnitude larger than Uruguay's, and the incentives for the country's banks to participate in the legal cannabis sector are commensurately larger. To be sure, Canada may also experience bumps along the road in terms of financial services, but indications are already that at least some of Canada's large institutions intend to engage, and they are presumably conducting the due diligence necessary to do so, in particular as it relates to the relationships with U.S. banks. Finally, about the United States. The U.S. itself is shifting towards regulating cannabis. It may not be obvious, given the hostile views on cannabis held by our current Attorney General, Jeff Sessions, but the U.S. is headed in the direction of cannabis legalization, or more specifically, federal law allowing for and setting guidelines around state-level legal regulation. For instance, an agreement was reported last week between President Trump and Senator Gardner of Colorado to develop legislation to protect states that legalize medical or non-medical cannabis from federal intervention. The debate at the federal level still has a far, far way to go before any law is enacted. And even if President Trump should change his mind and hand the reins of cannabis policy back to Attorney General Sessions, the states that have already legalized should not be expected to reverse course, and more states are likely to join them in the months and years to come. Already, 1 in 5 Americans lives in a state that has voted to legalize, more ballot initiatives are on the way, and public opinion is increasingly in favor of legalization, which has appeal across the political and ideological spectrum. To conclude, the Canada-U.S. relationship is obviously enormously important for both countries. On cannabis regulation, the Canadian government is certainly ahead of the U.S. federal government. But without putting a timeline on it, the United States is heading in a similar direction. And in the future, Canada should anticipate that the United States is more likely to be a partner in addressing shared concerns on cannabis policy rather than an antagonist. Thank you.
Could you just clarify two things? Your organization works throughout South America, Central America, and North America?
Yes, we do work most especially in Central and South America, but we do work in the Americas, particularly as the human rights issues and drug policy are global and multilateral. So we engage, for instance, in the OAS and in the UN, which is where all governments are at the